I'd like to welcome everybody to our webinar today. My name is Rich Barkham. I'm the owner of Cardinal Compliance Consultants. And today we are privileged to have Mr. Ray Arce from Marshall Melhorn Attorneys here to speak with us about issues commonly litigated before the OSHA Occupational Health Review Commission. Ray has over 25 years of experience in labor and employment law, including construction industry labor law, OSHA matters, litigation in state and federal courts. His experience includes litigating Family Medical Leave Act and employment discrimination cases, FLSA collective actions, Ohio prevailing wage law, and ERISA cases. Represents employers in collective bargaining and labor arbitrations. And he practices before the National Labor Relations Board, the EEOC, the OCRC, Occupational Safety and Health Review Commission, U.S. Department of Labor, OFCCP, and the Wage and Hour Division, the State Employment Relations Board, and the Industrial Commission and Unemployment Compensation Review. With that, and just as a couple of real quick reminders for everybody who have been on our webinars in the past, I do have everybody muted to cut down on any background noise. However, if you do have any questions, I would ask that you would please just go ahead and type those into our chat box, and we will get those answered either in the course of the webinar or immediately following the webinar. So with that, I am going to go ahead and turn you over to Ray. And Ray, they are all yours.
Okay. Hello. Good afternoon, everyone. Thank you so much for taking the time to tune into this program. I realize all of you are super busy. I realize your jobs are demanding, to say the least. So I'm going to try to get right to it and cover some things that hopefully might be useful to you in your day-to-day work and your day-to-day professions. So if we go to the table of contents on my presentation here, that'll give you an overview a bit of the areas that we're going to discuss. So I want to start out by talking about what the Occupational Safety and Health Review Commission is, how it is structured, what citations are common from OSHA on a national basis, and also what is at stake. Now, every case is different, but I'm going to bring up some examples about the kind of things that are at stake, so to speak, in litigation before the Occupational Safety and Health Review Commission. And then I get into the weeds of some of the details of the elements of the OSHA citations, and then issues that we see in the sort of the leading cases, the major cases that go before the Occupational Safety and Health Review Commission. So as we go on to the first slide, then this was very interesting to me, a little bit of a historical. I include a quotation on this page that goes back to the 1970s, and a Republican senator back when the Occupational Safety and Health Act was passed in 1970, and right on the heels of that was the legislation that created the Occupational Safety and Health Review Commission. And what stood out to me was, you know, this is a long time ago, nearly 50 years ago, and he points out that this is intended to be an autonomous body and not just part of the Department of Labor. Because I often have clients, you know, when I explain this, they're like, oh, so we have to fight OSHA before OSHA? Well, sort of. The Occupational Safety and Health Review Commission is definitely part of the Department of Labor, but it is not OSHA. And as you'll see in some of these decisions and the issues we go through, the administrative law judges and the Review Commission, they do disagree with OSHA, not infrequently. I mean, they definitely make decisions. They do not just rubber stamp what OSHA does. And of course, they operate just like a court of law. So as we'll get to, there are legal issues to be addressed, and the OSHA Review Commission is actually very experienced. They've been doing it like for 48 years, and as you can see, there's the main decision makers within the Occupational Safety and Health Review Commission are the administrative law judges. So there's an Office of Administrative Law Judges headquartered in Washington, D.C., but there's also offices in Atlanta and in Denver, and those administrative law judges really have a lot of responsibility in making the first decisions and conducting the evidentiary hearings. I'll speak to that more in a moment. And here I have some information. This may seem, if you're familiar with other government agencies, you know, the NLRB has 5 board members. Well, OSHA Review Commission has 3. So there's the chairperson, there's 2 other commissioners, and on this slide and the next slide, I'm just giving you some information about who they are. So as of last August, President Trump appointed Heather McDougal, who is right now the acting chairperson on the OSHA Review Commission. She's a lifelong management side, you know, no surprise there. She was nominated by Donald Trump. And she is going to be on the commission for quite some time. She's got a 6-year term, so she's got a term that's going to carry all the way until 2023. And again, you know, the predictions are that she's going to be on the conservative side, on the more employer-friendly side. The other commissioner, the second commissioner mentioned here is Cynthia Atwood, who was appointed by President Obama, and she is now on her second term and due to expire in April of 2019. So she's predicted to be a little more on the not so friendly to employer side. You know, no surprise there. She was appointed by President Obama, and that is her history going back before she became a chairperson. Before she became a commissioner. And then the third is James Sullivan, who was also appointed just this past August by President Trump. And as you can see, he was a lifelong management side labor and employment attorney. And from 2000 to 2002, he actually served as the management co-chair of the ABA's Committee on Occupational Safety and Health Law. So, I mean, this gives you some idea. And when Ms. Atwood's term is up in 2019, President Trump will get a third appointment. At that point, in all likelihood, you're going to have 3 Trump appointees serving as commissioners on the review commission. So, and as I mentioned, the review commission is a 2-step process. So first is what takes up the bulk of the process, and that's the proceedings before an administrative law judge who will travel, conduct hearings, and make a decision that is binding unless the loser petitions for review by the full review commission, and then if the commission grants review, then the review commission will get the final say in the case, and then the only layer of appeal beyond that is into our federal courts of appeals. On our next slide, I thought this might, and many of you may have seen this, OSHA publishes a list. They do this on an annual basis of the most commonly cited violations. So this presentation is about proceedings before the review commission, but remember that all of these cases that flow before the review commission start out with citations. So, and again, I'm guessing that many of you have seen these. By the way, what you see on this slide and on the next 2 slides is word for word from the OSHA website. So if you were to open the OSHA website today, go to their list. Their most recent list is for 2017. This is exactly what you'll see. Fall protection being by far the most citations issued in 2017, followed by hazard communication standard, scaffolding, respiratory protection. There's others who may be more on top of this, but my memory is that fall protection is at the top for many, many years of the most cited violations. And then here on the next slide, you'll see the next, you know, in order by the number of citations in 2017, lockout, tagout, ladders, powered industrial trucks, machine guarding, and then the training requirements associated with fall protection. So fall protection is big. I mean, fall protection is the #1 category of cited violations. And then fault protection training actually ends up in the top 10 as well. Electrical wiring comes in at number 10. And again, OSHA gives you a description of, you know, what the typical violations are under each of these 10 categories. Okay, so now I want to talk about what can you contest. So you're an employer, you've received a citation and proposed penalty, you're either about to go through an informal settlement conference with the area director, maybe you've already been through that informal settlement conference, and for whatever reason, you've not been able to reach an informal settlement agreement with the area director. So what can you contest? Well, you can contest citations, the items within citations. You can contest the proposed penalty involved with all of the citations or just certain items of the citation. You can contest all of the abatement measures or those abatement measures required in connection with those citations that you are contesting. So usually you contest, you contest all of it. You contest the citations, you contest the proposed penalty, and you contest the abatement measures. You don't have to. I mean, you can contest any one of these elements, and a lot of people don't know this. I mean, you can contest abatement measures without even contesting the citations. And, you know, depending on your area director at OSHA, you can reach an informal settlement agreement that'll put to bed some of the citations and then leave open other issues that, you know, you're going to go to contest with. The added information here that, again, you may be aware of, but as of the penalties. So OSHA has, you know, since the outset, since the 1970s, had penalty ranges that are associated with the various categories of citations. And here on this side in the next slide, I'm giving you the current, because as of August of 2016, the OSHA and the law was changed so that OSHA now has to update the penalty ranges based on inflation and, you know, from year to year. So you're going to see slight increases. Every year, you're going to see a bit of an increase on the maximums that are associated with the various citations. And as of, this is straight from the OSHA website, as of January 2nd of 18, and these penalty ranges will be in effect until January of 19, you'll see the numbers. So whether we're talking about, and again, posting violations are typically going to be $0 or $250. They're very, you know, they've got a maximum penalty that really doesn't come into play very often on posting violations or other than serious. But technically on all three, posting violations other than serious, and then serious, which is really by and large the largest percentage of the citations that, you know, are a real problem and that, you know, you would contest or may contest, are going to be in that category or more severe, but in the serious category. But again, maximum penalty, $12,934. And remember that just, you know, 2016, just 2 years ago today, the maximum penalty for a serious citation was $7,000. Now we're very close to $13,000. So, you know, it's certainly enough to get employers' attention, and these are the ranges you're looking at. And my experience with OSHA is that anything serious, they're going to propose the max. I mean, they'll bargain with you, they'll reduce it, but they're going to start with the max as a proposed penalty many, many times for a serious. And today, the proposed max is going to be nearly $13,000. Here, you've got the max, which is, you know, a little bit jaw-dropping. Willful and repeat, the max, again, just 2 years ago, the max was $70,000. Today, it's $129,000, and it's going to go up a bit every January, depending on inflation. And then the category you don't see very often, but failure to abate, that's a daily penalty of up to nearly $13,000. And, you know, that doesn't get handed out very often, but if it happens, you're usually going to end up with a 30 days worth of penalty on a failure to abate. And then, as most of you know, a substantial, vast majority of contested cases end in a settlement. So even when you've been unable to negotiate a mutually acceptable informal settlement agreement with the area director, the notion of submitting a written contest and sending that to an adversarial proceeding before an administrative law judge of the review commission. You're going to have a solicitor of labor attorney on the other side. But guess what? Even in those situations, time and time again, those cases tend to settle. There are some trials, and we're going to cover some. I got decisions here where there was trials, but what I'm saying is, don't be afraid. If the employer, you got to make an intelligent decision. You got to know what the potential outcome is going to be, and of course you got to know the cost involved. But contesting citations will often lead to settlements where, at least in the dollars and cents terms, the penalty the employer ends up paying is less than the area director was willing to agree to in the setting of an informal settlement conference. Okay, so here I have a number of thoughts about why contest citations, and there really are some different considerations. And so one of them that is not always at the forefront of an employer's mind, but if you get a willful citation, that is a big deal. There is federal statutes that allow for a criminal charge against the employer as an entity or against individual managers, where if you've been cited and there's been an employee fatality, OSHA doesn't do it, but in the right circumstances, egregious type circumstances, the U.S. Department of Justice can pursue criminal penalties against an employer, and the launching point is a willful citation before OSHA. Doesn't happen every day. I acknowledge this is rare, but if you're facing a willful citation where somebody died, that really is a consideration of wanting to contest the thing, especially if you think that OSHA's got it wrong, that they're going overboard by classifying it as willful. And I've got more slides that get into the details, the legal elements of willful. Then other reasons. Well, abatement. And I put in here that, sometimes employers contest in order to avoid abatement. It's not really avoiding abatement. I think maybe, I'm sorry, I was one slide ahead. But it's to control what's involved with abatement, and also to bring OSHA down to reality. There's times when the OSHA area director has certain notions about abatement, and they're not realistic. They're overkill, multi-millions of dollars of engineering changes and stuff. So sometimes the contest procedure can serve to bring OSHA down to reality and get an agreement on abatement measures that are actually feasible and are not so expensive that they might put your company out of business. Another reason to avoid citations, and this doesn't happen, in every case certainly, but OSHA, and there's other government offices that do this, but the OSHA offices will issue press releases. So they issue citations, and sometimes this ends up in the local newspaper, but they can issue negative press releases about the employer. It's from the employer's standpoint, it's a negative press release. They're saying, we cited the employer for this and that and the proposed penalty. So, as I say here, some people refer to this as regulation by shaming, and OSHA is very aware that, the effect of their press releases. So they do it. They do it on purpose, and they do it because they're trying to create a scare tactic, or how should I say, a disincentive for others out there to violate OSHA requirements. Another consideration on whether to contest is some employers are very dependent on bids for contracts, like in the construction industry, employers that do a lot of business with the federal government. And so when that employer submits a bid for a given contract, the company or the federal government that you're involved with will grade the proposals, rank them by the bidders, and your OSHA history can be a big negative. So this is another reason that, maybe the proposed dollar amount of the penalty on an OSHA citation is not going to put you out of business, that's not a reason to contest if that were the only issue. But maybe you've got a willful citation, maybe you've got a serious citation, and maybe you know that if that sticks, that your company is going to have serious difficulty with future bids. You know, again, another reason to fight, to contest citations. And then down here, I noted that you are, you know, again, it's up to the area director, but if you're in a situation where OSHA issued a press release, you head into the informal settlement conference, you can, as part of the negotiations, try to get OSHA to agree that they're going to pull their negative press release off of their website. And they may or may not agree to that, but, you know, that's certainly a topic you can try to get worked into your informal settlement agreement if possible. There is some belief that contesting citations will actually minimize future inspections. Now, I don't know, the folks at OSHA may not agree with that, but, you know, there's one school of thought that says you don't want to roll over on every citation. All you're going to do is get more interference, more inspections by OSHA, and that in the right case, you're better off contesting citations to keep OSHA honest and to actually hopefully get less inspections over time. Another consideration, and this is for those employers that are already in some deep doo-doo, they're already, you know, in the severe violator enforcement program, and that's one that you don't want to be in it, and if you're put in it, you want to be out of it as soon as possible, because that opens the door for OSHA to do nationwide inspections if you're an employer that operates on a nationwide basis. And obviously, the more inspections, the more citations you're going to get, and the more interference with your business. And finally, that last bullet point on this page 11, that hints to the elements. So all I'm saying there is that many employers come to me when they get a citation. They don't know the legal technicalities of the elements, but their intuition, you know, their common sense tells them that, hey, that citation that they're citing, that doesn't apply to us. Or, you know, we didn't violate it. No employees were exposed. We didn't know about it. All those common sense feelings that employers have, those do fit into the elements of, you know, being held liable for an OSHA violation. And if you think you've got good evidence on these points, you know, you can win. You can take these things before an administrative law judge, and it is possible to win them. Okay, so now from this point, I'm going to start getting into some actual cases. So what I did here is, and any of you can do this, if you look on the OSHA website, not OSHA, OSHA Occupational Safety and Health Review Commission, which has a separate website from OSHA, and then put in, I think it's decisions or current decisions, and you'll see they give you a list of 19 cases that are currently pending review by the Review Commission. So what does that mean? That means that those are cases where there's already been a decision, you know, a hearing before an administrative law judge. There's already a written decision by an administrative law judge, and the employer, well, or the, you know, the OSHA, the Department of Labor, are seeking review. So they've asked the Review Commission to review what the ALJ has decided, and the OSHA Review Commission does not grant review in every case, but there was a wealth of information in the list of those 19 cases that are pending review right now. And the one that caught my eye, and I labeled this slide, what is at stake? So clearly, this is not every OSHA case, but BP. So I think probably most people on this call or on this webinar are familiar with the BP refinery in Oregon, Ohio. Well, that refinery, and BP has had a long history. Okay, we all know about the terrible fire in Texas at one of their refineries. So in 2010, the OSHA area director, well, OSHA started the inspection in 2009. In 2010, the OSHA area director, and it wasn't Toledo, by the way. This may stem from earlier proceedings with BP, but it was actually the Milwaukee OSHA office that led the thing. But he got $3 million in proposed penalties, handed down by the OSHA area director in 2010. So BP took it to hearing, you know, contest. Administrative law judge held a 19-day hearing in 2012. And by the time there was time for an ALJ decision, it had all been narrowed down to 41 alleged willful citations of the Process Safety Management Standard, PSM, which I'm guessing many of you are aware of. But I quoted there, the PSM standard contains requirements for preventing or minimizing the consequences of catastrophic releases of toxic, reactive, flammable, or explosive chemicals. So obviously, you know, that's very serious business. If these things happen, many people die. So, you understand the seriousness with OSHA and a history with BP. Well, the administrative law judge in August of 2013 vacated almost all of the citations, affirmed only 5 of them, reclassified them as serious instead of willful, which brought the penalty down for each one of them down to $7,000 each, for a total of $35,000. Now remember, the area director had proposed $3 million in penalties. So clearly, you know, there's room to accomplish something in these proceedings. And another, you know, interesting thing is that this inspection started in 2009, so 9 years ago, and the decision by the ALJ was in August of 13, nearly 5 years ago, and the review commission, as of today, has still not made a decision. It's still pending. So here's some background on that case, and I thought this was interesting. So this is going to come up in a couple of points during the course of the presentation here. But what about self-audits? You know, we know that OSHA encourages, if you've been to informal settlement conferences, in fact, sometimes the OSHA area director will want you to promise to bring in consultants, you know, like Rich Barkham and his firm. You know, there's a lot of firms out there. But what's OSHA's position? So this, even though I quoted the administrative law judge here, who said that although the undersigned is troubled by the Secretary's ill-advised use of the Middow report, what happened here was that when OSHA launched this inspection in 2009, they learned that BP had spent $6 million on an engineering firm the year before, starting in 2008. BP had spent more than $6 million getting an engineering study done by an outfit out of Cleveland, Middow, and OSHA said, okay, first thing to BP, show us everything Middow has given you. And from that, OSHA went ahead and just cited them for everything in the audit report prepared by Middow. There was actually more than one. There was drafts of the report. You know, this was pretty elaborate. And so the ALJ said, look, I'm going to decide the thing, but the ALJ cited OSHA policy. So I quoted it there. OSHA published a final policy on self-audits back in 2000, July of 2000, quote, OSHA will not use self-audit reports as a means of identifying hazards upon which to focus during an inspection. And this ALJ, you know, wrote immediately in his decision that OSHA did exactly that and called it ill-advised, but said, that's not why I'm vacating, you know, a lot of these violations. And, you know, the decision by this ALJ is like 50-some pages long, but it goes through a number of issues. And suffice to say, the Secretary of Labor was reversed on a ton of things by this administrative law judge. And clearly, when you read the whole thing, you know, the administrative law judge says, well, you know, I'm not doing this because OSHA relied on a self-audit. But, you know, he wrote that he didn't, but clearly he put OSHA to task for having, you know, relied on this engineering report that BP spent $6 million on to go ahead and hang the company or try to hang the company. So when you look at Occupational Safety and Health Review Commission decisions, you're going to see the same 4 elements. Every single decision by the Review Commission is going to go down this formula, put the burden of proof on the Secretary of Labor by a preponderance of the evidence. You know, lawyers care about, you know, are we talking about preponderance of the evidence, beyond a reasonable doubt, clear and convincing evidence? This is the lowest standard, preponderance. So if you were to put it on a scale, if it tips a little bit in favor of the Secretary of Labor, the Secretary of Labor wins. You know, if you balance the competing evidence on these elements. So let me start with a couple of examples of how the administrative law judges of the Review Commission deal with the issue of employee access or exposure to the violative condition. Sometimes they call it the hazard, all right? But the question there is reasonable predictability, and another key phrase you got to understand is zone of danger. Both of those concepts can be argued, but what everybody's talking about when this issue is litigated is, okay, what exactly is the area that we're talking about where employees might be in danger of being hurt? So that's the zone of danger. You got to define what that is. And then, is it reasonably predictable that an employee would actually enter this zone of danger? So even though the Secretary of Labor carries the burden, if you actually read these decisions, I mean, OSHA pretty much presumes pretty hard that, you know, that employees can be in the zone of danger, and they really need some serious convincing by the employer that it was not reasonably predictable that any employee would be in the zone of danger. And again, a lot of the times when this issue is litigated, nobody's been hurt. You know, it doesn't leave much room for an employer to argue there was no exposure to a hazard when somebody actually got hurt. So, and here's some of the key phrases here. That if the employees perform the job in a manner that is dictated either by operational necessity or inadvertence. So again, OSHA builds into this the notion that an employee will make a mistake. So OSHA clearly thinks that it is reasonably predictable that employees are human beings, and especially when we're talking about a job that is repetitive, you know, time and time and time again, day after day, that employees will kind of zone out and, you know, put themselves in the zone of danger. Even if they've been trained not to, OSHA considers it reasonably predictable that employees will inadvertently fail to do what you trained them to do. And in this example, in this case, like a lot of these cases, it's where an employee managed to get his hand, a finger smashed in a machine, and as you can see, the employee managed to put his hand underneath a guard and allowed the hold down piston to you know, come down on the employee's hand. The employer said, hey, we taught him never to do that. There's a guard there. The employee should have never put his finger there. But what the ALJ emphasized in this case is, yeah, but sometimes there's very small stock, you know, very small pieces of whatever that the employee has to hold in place. And when they're that little, you know, if they're expected to do their job, they got to hold it in place, and they're doing it with their fingers. So, you know, this is an example of an employer who's not able to convince the administrative law judge that there was no exposure to the hazard. According to the administrative law judge, given the small stock the employees had to work with, and the testimony that, look, on the day that this happened, there was nothing unusual about how I was performing this task, and other employees said the same thing, that, you know, putting a pieces of stock this size, holding it in place, that is not an uncommon thing. With those set of facts, you're going to lose. OSHA's always going to find exposure to the hazard. Here I give you another example that has to do with fall protection. And I've had experience with the same kind of thing. And another factor that comes up in this case, this gate precast case, is temporaries. And this comes up in another case too, where the employer argues that, well, they're just temporaries. We gave them instructions, and basically we told them to just stay out of the way. You know, don't go in the zone of danger. We put up red tape up on this roof. You know, everybody's told to stay more than 6 feet from any edge of the roof. And, you know, especially our temps that we got from Labor Ready, they were instructed never to go within 6 feet of the unprotected edge. OSHA didn't buy it. OSHA says no way. That under these circumstances, OSHA says even if you instruct these guys, it is still reasonably predictable that for them to actively engage in the type of work that they had to do, that they would have to move about the entire area. And then they basically faulted the employer by saying that if you tell employees to stay away from that 6 feet, area, that they mistakenly might think that it's safe as long as they stay out of those taped out areas. And OSHA's saying, look, when you're on a roof, it's never safe. There's always going to be some fall protection procedures you got to go through. Now, depending on the size of the roof, they might not have to be actually tied off, but the employer and this is an example of, an employer who, and like a lot of employers, they don't have a ton of materials about, evidence of training to their temporaries that come from a temp agency. And, employers typically think, well, they're just temps. We don't have to pile on all the training. And a lot of employers figure we're not really going to put them in harm's way. They're just temps. But OSHA, OSHA's going to see that in these kind of circumstances as employees that are being exposed to a hazard. And whether they're temps or not, it's still your OSHA citation. And then I'll give you an example from BP Products, which is, I think the case was just so big that, OSHA continued to press things where, for example, one of the citations was for having an undersized relief valve, pressure relief valve on a pressure vessel. But the thing is, BP had taken the vessel out of service 4 months before OSHA started their inspection. But then when OSHA got the engineering report that BP had paid for, OSHA saw this issue about these pressure valves with undersized, pressure vessels with undersized relief valves, and OSHA cited them. But how can there's no employee exposure at the time of the OSHA inspection when the thing had been taken out of service 4 months before OSHA's first day on site. Should have been a no-brainer, but it took all the way to an ALJ decision to get that thing reversed. And then here's an example from this Angel Brothers case. Is another scenario that comes up a lot with OSHA litigation, and that is, well, the employer says, we didn't know. So forget about, now I'm not talking about exposure, employee exposure to the hazard. Now I'm talking about the employer's knowledge of the hazard. And on that one, I'm just pointing out that, many employers will try to blame their supervisor. So you get in one of these cases, and again, these same points can be hammered out before the area director at an informal settlement conference. But, you've got an employer that says, it's our supervisor's fault. We've trained everybody a million times what to do, what not to do, but we had a bad supervisor who, engaged in his own misconduct. Well, it usually doesn't fly. As OSHA points out in these cases, that a supervisor's knowledge is almost always imputed to the employer. So, employers, you're deemed almost always to know what your supervisors know. And in the construction industry, that goes right on down to foreman. And so the case I'm citing for this proposition is Angel Brothers Enterprises, where it was a trench, and the ALJ affirmed a willful citation against this employer, and it was all on the supervisor because there was a supervisor who was standing up at the top edge of the trench. He watched the employee work below, and the employer still tried to argue the employer had no knowledge. But, the point was that the subordinate employee was down in a trench with no protection, no trench box. And the foreman was standing right there looking at him. So, the administrative law judge, it says that this case is not just a subordinate not just a supervisor who observed a subordinate engaged in misconduct, but this supervisor actually helped create the violative condition. And you'll see, I bring this case up later on another point. But basically, what the supervisor's explanation was that he and the subordinate employee talked about it before the employee got down in the trench and mutually decided that it was faster if the employee just went down there without a trench box and sort of quickly accomplished what he was trying to accomplish. Under those circumstances, you're never going to convince OSHA that you didn't have knowledge as an employer. And then here, knowledge. Another example, BP products. So now we're talking about heat exchangers. And what OSHA did is, you know, they got the self-audit report and says, aha, you've got heat exchangers that are missing pressure relieving devices, PRDs. But again, the OSHA, the ALJ says OSHA inspection started in October of '09. BP was not aware of the missing PRDs, pressure relieving devices, until BP received their self-audit report in December of '09. So no knowledge. And then I included this slide that the Secretary of Labor made this argument, and area directors will make this argument too, which was, okay, BP says they didn't know about the missing PRDs, but they should have. With reasonable diligence, you should have known. And but the administrative law judge says, hey, it is not easy just by looking at piping to know that PRDs are missing. And then, you know, a little bit of jab at the OSHA inspector. The OSHA inspector was at BP's refinery here in Oregon for 2.5 months, 5 days a week. He didn't realize there were missing PRDs on those pipes until the mid-out report was produced by BP. So, you know, it's a little bit of, it's got to be a fair fight. And OSHA here, you know, was not fighting fair with BP for citing them for this PRD issue. Okay, willful. So I wanted to point this out because I think it's safe to say that one of the major things is going to be, you know, in deciding whether to contest a citation is whether you receive one that is willful. And there's the legal standard, you know, conscious disregard or plain indifference for the safety and health of employees. Now, that leaves a lot of room for interpretation, and, you know, there's a lot of room to fight in these cases about whether a willful characterization is really valid or appropriate in a particular case. And remember, compared to 2 years ago, the penalties are way higher. The willful carries nearly $130,000 max for a citation today. And then let me point this out, which was pointed out in the BP case. So the administrative law judge says, hey, hold on a second though. There's a safe harbor provision in OSHA's final policy about self-audits. That's a policy going back to the year 2000. And basically it's quoted right there that if an employer is responding in good faith to a violative condition discovered through a voluntary self-audit and OSHA detects the condition during an inspection, OSHA will not use the voluntary self-audit report as evidence that the violation was willful. That's huge. I mean, you know, basically then, if you're paying outfits like Cardinal Consulting or whatever to, you know, give you a self-audit and you jump on it, because look at it, you do have to promptly take diligent steps to correct the violative condition. So it's not just paying for the report. When you get it back and it says there's problems, you got to jump on it. But as long as you do that, it should be absolutely off limits for OSHA to tag you with a willful citation in those circumstances. And here the administrative law judge just rattled it off and said, look, when BP received this report in '09, they jumped on it. We find no evidence that there was a heightened aware of illegality or, you know, reckless indifference to anybody's safety, and that therefore the citations were classified from willful to serious. And remember, there were 41 proposed willful citations. So this went from nearly $3 million down to $35,000 because of this determination between, you know, not willful, but bring it down to serious. Okay, I just got two more topics, and then if there's any questions, you know, I'd be happy to take some questions. So here's one that's an affirmative defense. And many of the things that play into this are the same kind of things that play into the other elements. But remember, everything else I just discussed are the things that OSHA has to prove. So an affirmative defense means that, okay, even if OSHA can prove all four of the things we were talking about, all four of those elements, there's still a way out. And that's if the employer, and here the employer carries the burden of proof of proving that this injury resulted from unpreventable employee misconduct. And there's the four elements. And it's all on the employer. And it is not easy to win on this, obviously. So, employer, you got to establish a work rule designed to prevent the specific hazard that's at issue that you got cited for. You have to prove that you as an employer adequately communicated the safety rules to the employees in question, that you as an employer actually took steps to discover violations. So it's not just, you know, you turned a blind eye after you trained them. You actually have to monitor whether anybody's violating what you told them. And then, if you find violations, you got to enforce it. You got to punish them. You got to fire them. You got to take disciplinary action. And here, this Gate Precast company in this case, you know, tried to argue unavoidable employee misconduct, but the employees who were you know, engaging in the dangerous behavior, they were temps. They were temping, you know, and the employer did not have any work rules regarding temporary employees to tie off. You know, this was a fall protection case. So according to OSHA, or the, you know, OSHA Review Commission, then really you didn't have any rules. They're non-existent. You can't show them to me. You can't prove you gave them to these temporary employees. So, you know, this employer failed on the unpreventable employee misconduct. I got another case here, aerospace testing, where, again, this is the same case I was talking about earlier about a sheet metal shop. These were actually all union sheet metal workers. And again, OSHA builds into this thing the notion that employees are never going to, you know, you're never going to win on unpreventable employee misconduct when OSHA says, okay, what you're blaming the employee for is nothing more than common human errors, such as neglect, distraction, inattention, or inadvertence by the operator. So OSHA uses this as a way to say, look, you cannot blame the employee. In your typical case, you're not going to get out of an OSHA citation if the Secretary of Labor can establish all the elements. You're normally not going to get out of it by, you know, blaming the injured worker. Here's some more reasoning from the administrative law judge, which is heavy burden on the employer. I mean, the employees testified that they had toolbox talks, but there was nothing specific enough. There was nothing written, nothing specific about getting your hand underneath a guard. And then the administrative law judge says it may have been reasonable for the company to rely on, you know, the prior training of its employees, but it's definitely not enough to...
Muted.
Employee misconduct. Similar situation here, the Angel Brothers case.
Hold on.
I don't know.